Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. In a time of change and uncertainty, e-Immigration's case management system and dedicated team are here to help you keep calm in the chaos. Talk directly with the award-winning e-Immigration team to see how their software can help you manage your cases, clients, forms, and firm with ease. Get a personal demo at get.eimmigration.com/demo or click on the link in the show notes. And of course, mention Immigration Review Podcast on your demo for a special offer. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. The slow weeks have ended. The time of the orc has begun. I mean, of many cases. The orc cases. I know, the metaphor is flailing a bit. But do any of the kingdoms in Middle-earth have an immigration policy? Oh, if only Tolkien had lived longer. Also, why do I feel that if any would have had one, it would have been the dwarves, right? So much immigration news as always, but I'll focus on two reports. First, the wild reporting of the FBI charging a state court judge for, I guess, obstructing the arrest of a non-citizen in her own courtroom. Terrifying stuff. But two, the administration's backpedaling on their blanket termination of thousands of student visas in response to the tsunami of lawsuits from the immigration bar and resultant tsunami of federal court wins. Don't get me wrong, the damage is likely largely done. How couldn't international students not think twice now about accepting offers to study in the United States? But still, rock on everyone. Rock on, immigration bar. The bar fought back and notched its first widespread win. We'll see if it holds, but celebrate the good, everybody. You gotta celebrate the good. Including this week, a win for non-citizens from the highest court in the land. Here are your 7 cases. First up is Velázquez v. Bondi, published by the U.S. Supreme Court on April 22, 2025. This case is about filing deadlines and voluntary departure. Justice Gorsuch authored the majority opinion, with Justices Thomas and Alito, Kavanaugh, and Barrett in dissent to varying degrees. Mr. Velázquez is from Mexico and entered the United States without authorization about 20 years ago. Quote, since then he has made his life in Colorado. There he attended high school, some college, and met and married his wife. The couple has an 11-year-old son and a 10-year-old daughter, both U.S. citizens. Mr. Velázquez and his wife have raised their family in a home they own outside of Denver, where he also owns and operates a small business. End quote. I can only imagine Justice Gorsuch includes this information out of sympathy for Mr. Velázquez, who it appears does not have a criminal record, but who became the subject of removal proceedings in 2011. Eligible for asylum and voluntary departure at the time in 2011, an immigration judge denied asylum, but granted voluntary departure. Heads up though, if that NTA was deficient, he's now accrued his 10 years for non-LPR cancellation of removal, because the stop time rule never triggered. And that's assuming that he can make a hardship showing. Thank you again for that one, Justice Gorsuch and Ms. Chavez. Anyway, Mr. Velázquez got voluntary departure, receiving the maximum 60 days to depart. Quote, when the government extends this option, it effectively makes detention and removal contingent. Officials may detain and remove the individual only if he remains in the country after his voluntary departure period has expired. Suspending removal proceedings in this way can benefit both the government and the individual. For the government, an individual's voluntary departure saves the cost and effort associated with detention and removal. For the individual, it not only allows him to choose how and when he leaves the country, it also allows him to avoid substantial penalties associated with a forcible removal. End quote. Nice quote to use, too, that first part. If ICE ever tries to detain or refuses to release your voluntary departure recipient client. Mr. Velázquez's 60th day to depart fell on a Saturday. The IJ caught this when the IJ ordered voluntary departure and expressly extended the deadline to the following Monday. Only if Mr. Velázquez failed to depart by that Monday would he, quote, face removal and the penalties associated with it, end quote. Mr. Velázquez appealed the IJ's decision denying asylum, as is his right. That stays the 60-day voluntary departure period. The BIA affirmed asylum denial and, as it pretty much always does, granted a new 60 days to depart with voluntary departure. The BIA gave all the usual rights and warnings again, including, under the regulations, that Mr. Velázquez could file a motion to reopen based on new and previously unavailable evidence, but that he must do so before the 60-day voluntary departure period concluded to avoid the failure to depart penalties. And of course, here we go. Mr. Velázquez did file that motion, relying on Justice Gorsuch's then recent Chavez decision to argue that now he was eligible for non-LPR cancellation of removal because the stop time rule never triggered, meaning he's got the 10 years. He served ICE on a Friday, within the 60 days, but the BIA apparently didn't receive the motion, or say it received, or note that it was filed until the following Monday, because we still operate in this absolutely insane world of paper filings for many cases. You know, I bet FedEx dropped it off with the BIA on Saturday too, but that the BIA didn't scan it in, because of course it was closed. But I have no proof. The BIA denied the motion on the merits, but also because it believed the motion untimely. See, the BIA's 60-day period had also lapsed on a Saturday, and unlike the IJ, the BIA was not willing to extend that to the following business day, as occurs as a matter of course in nearly all other areas of law. Having filed a motion to reopen after the voluntary departure period expired, the BIA held that it couldn't even entertain the motion. The BIA held fast on a motion to reconsider, and the 10th Circuit affirmed. But a Supreme Court majority did not, resolving a circuit split in favor of the 9th Circuit. Clearly important to Justice Gorsuch, failing to do so not only takes away voluntary departure and the motion to reopen right, but, quote, affects an individual's exposure to detention, removal, and fines, and carries with it serious ramifications for his ability to seek lawful status for years into the future, end quote. All for failing to extend a weekend deadline to the next business day, where, by the way, if I'm correct, the BIA doesn't even accept weekend filings anyway? Too much for the majority, and more importantly, a holding inconsistent with the statutory text to the majority. The deadline for Mr. Velázquez to depart depended on how the court reads the word, quote, days, end quote. That makes this like the third decision in a row where the holding is coming down to how the Supreme Court reads one word. Now, the BIA, acting like a, quote, ordinary reader, end quote, read the word to include calendar days. So much shade, justices. The BIA, ordinary as they are. But these are not ordinary times. This is not an ordinary statute. Voluntary departure is no ordinary thing. Quote, here evidence suggesting the possibility of specialized meaning does exist. In legal settings, the term days is often understood to extend deadlines falling on a weekend or legal holiday to the next business day. Various federal rules reflect this understanding, end quote, as do the federal rules of civil procedure and the various circuit appellate rules. The Supreme Court, quote, generally presumes the new provisions should be understood to work in harmony with what has come before, end quote. And here the immigration agencies have been creating regulations for like 70 years, extending deadlines to the following Monday or other business day when a deadline falls on a weekend or a holiday. Look no further than 8 CFR section 1.1h. As such, IJs do this all the time, expressly, explains the majority, citing AILA's Amicus brief. Go Ayla! Rejecting Justice Alito and the government's other arguments, the majority permitted the Monday motion to reopen filing. By the way, without saying it, this is definitely the type of decision that could come out the other way if Chevron deference still existed. The Supreme Court also held, of course, that it had jurisdiction to review these issues. Else, how could we have the decision? I&A Section 242A1 limits circuit and Supreme Court review to final orders of removal. And Mr. Velázquez was technically seeking review of a motion to reconsider the denial of a motion to reopen. And the final order that he was trying to reopen and then reconsider became final when the BIA deemed the voluntary departure period expired. But at the end of the day, we're talking about a legal dispute over voluntary departure. The Solicitor General wants non-citizens to have to also challenge something about removability per se to obtain federal court review. Like, I don't know, the denial of asylum or the denial of the motion to reopen. But to the majority, and the Solicitor General actually, that would require some litigants to, quote, make up a completely meritless claim in order to get jurisdiction, end quote, and that's absurd. Indeed, explains the majority, Section 242A1 doesn't even mention, quote, removability, using instead the phrase final orders of removal, end quote. And that's what we have here. Sufficiently to the majority for jurisdiction. Has Justice Gorsuch ruled against a non-citizen in an immigration case? I don't know, maybe Pugin? Some of Jennings for sure. I'm sure there's a couple more. Either way, and for reasons that I'm sure he would explain are based simply on the statutes, Justice Gorsuch has developed into quite the dark horse for non-citizen-friendly rulings. A bit more, as it is the Supreme Court. Astute listeners will recall that the reviewability of withholding and Convention Against Torture denials in withholding-only proceedings after reinstatement remains pending before the Supreme Court, awaiting a decision this term. That legal issue turns on how the court wants to read Nasrallah and the concept of final orders of removal. I only skimmed the dissents, but based on the majority's discussion, it appears that Justices Thomas, Alito, Barrett, and Kavanaugh will not only sympathize with the government's position in that forthcoming case, but would have extended it here to bar jurisdiction. Restated, it appears that the government might have 4 votes to cut off circuit review of denials of withholding of removal and cat protection in withholding-only proceedings post-reinstatement of a final order of removal if it all happens over 30 days after the initial final order of removal. Does the government have a 5th vote? We shall see. We shall see. Here's looking at you, Chief. Then again, Justices Barrett and Kavanaugh expressly did not sign on to that portion of Justice Thomas's dissent and issued a dissent on jurisdiction of their own, which is slightly watered down on the jurisdictional issue, if you ask me, so maybe they're not quite willing to show their hands yet. Who knows? A dangerous game trying to read tea leaves with the Supreme Court. But I'll be taking bets about what happens. No bets will be accepted, though, against Justices Thomas and Alito taking the no jurisdiction position in the forthcoming case, as it would not be fair to take such a bet. And that is Velázquez v. Bondi. Next is matter of AAR, published by the BIA. This case is about Convention Against Torture claims for MS-13 members from El Salvador. How timely of you, BIA. How timely. Mr. AAR, an acronym of course, is from El Salvador. I'm not sure because the decision doesn't say, but I suspect he entered the United States unlawfully as a minor. But I'm not sure. He joined the MS-13 gang while in the United States, so that's definitely something noteworthy and not great about America. Then, while part of that American-based gang, he murdered someone in 2006. He completed his federal sentence for murder 15 years later and was removed to El Salvador in 2021. He entered unlawfully again the next year. Deemed to have a reasonable fear of persecution and torture in El Salvador, DHS placed him in withholding-only proceedings after reinstatement. Deemed eligible only for cat deferral, and IJ granted it. So I guess, can send Mr. AAR anywhere else that'll take him, provided he doesn't also have a reasonable fear from that country, and accept El Salvador, which is too bad for the administration, given that that is the country's gulag we are currently using. but the BIA reversed the IJ. So Mr. AAR will be going back to El Salvador, it seems. By the way, this is precisely the type of case that if it was petitioned for review to the Third Circuit, the Supreme Court is about to decide whether or not the Third Circuit would have jurisdiction. Anyway, standards of review are important. Quote, the question of what will happen to an applicant is a factual finding the BIA reviews for clear error, end quote. The dead fish standard in the First Circuit. But whether that meets the legal definition of torture, that's a mixed question of law and fact that the BIA reviews de novo, explains the BIA. So remember that for your own appeals counsels when the procedural posture is reversed. Think whatever you want about MS-13 and former members, but the claim here isn't frivolous. In El Salvador right now, there's a, quote, state of exception, end quote. And, quote, under the state of exception, which must be renewed monthly, security forces are empowered to arrest anyone suspected of belonging to a gang or providing support to gangs, end quote. What they do with them next? Well, it seems that at best they end up in that gulag that the US is now helping to finance. I believe their president has bragged that no Salvadoran has ever left that prison. The BIA agreed with the IJ that Mr. AAR will be arrested and detained immediately under the state exception, if nothing else, because of the literal MS tattoo on the back of his head. For all your future Salvadoran cases as well, counsels, here's the BIA stating, quote, information about his criminal history and gang affiliation would likely be shared with the Salvadoran government through the Criminal History Information Sharing Program between the United States and El Salvador, end quote. So definitely some facts here supporting a CAT or withholding a removal or even asylum grant under the right circumstances. In addition to the record, quote, establishing a history of widespread detention of prior and suspected gang members in El Salvador, end quote. So why overturn the IJ, BIA? Well, like in the 2002 decision matter of J.E. with Haiti, the BIA sees the state of exception, quote, a lawful enforcement sanction designed to protect the populace from criminal acts committed by gang members, end quote. But didn't you just hold that a lawful sanction can't defeat the CAT in matter of HCRC, episode 217? Well, let's dive into this case. First, the BIA believed the IJ didn't back up the torture findings with enough facts. Gotta link each step in the hypothetical torture claim. That old favorite, matter of JFF. Yet at the same time, explained the BIA, the IJ, quote, relied on an expert witness's report and reports from non-governmental organizations, including Amnesty International and Human Rights Watch, that state some detainees and suspected gang members have been subjected to mistreatment and physical abuse rising to the level of torture, end quote. Well, what's wrong with that? Well, without specifying entirely, at least to me, the BIA held that the IJ didn't tether the torture finding to Mr. AAR specifically enough. Expert reports and respected NGO evidence doesn't, apparently, say anything about the likelihood to Mr. AAR specifically. Although I can only imagine that the expert would have opined on that a bit. Kind of unstated in the decision. 70,000 Salvadorans have been locked up under the state exception, explains the BIA, and hundreds have died. Hundreds. But I guess the BIA is kind of implying that cuts against Mr. AAR because it of course implies that tens of thousands still live. Quote, the applicant has not meaningfully explained why he, an over 40-year-old deportee whose gang activity occurred while in the United States, would be similarly situated to those who have been the victim of severe physical violence by prison officials, such that he established the requisite likelihood of future torture, end quote. Quote again, the evidence the immigration judge relied upon does not evaluate whether there are characteristics or circumstances that make certain classes of detainees, such as deportees from the United States, any more or less likely to be victims of torture, end quote. So make sure your evidence in your expert report does. Moving on, lots of BIA case law says that bad prison conditions alone won't satisfy the CAT. Unless, of course, the quote evidence demonstrates that poor or life-threatening prison conditions are intentionally and deliberately created and maintained by authorities to intentionally inflict severe pain or suffering, end quote. So there's your BIA standard. And I mean, is that not the whole point of staging photo shoots of this prison in El Salvador for gang members? To show the world and would-be immigrants of this deliberately terrible prison that they may find themselves in El Salvador if they come to America? Undiscussed. None of the current U.S.-El Salvador cooperation stuff is discussed at all on this decision, nor does the BIA, to their credit in my opinion, refer to the respondent or MS-13 as terrorists. Horrible criminal gang, yes, absolutely. But the BIA does not use the word terrorists. Anyway, to make that showing about intentionally terrible prison conditions, quote, specific intent for purposes of cat protection requires a showing that the actor had the intent to commit the act as well as the intent to achieve the consequences of the act, end quote. Lots of standards to remember in this one, if nothing else. But it was unmet here, despite the expert and Department of State itself reporting that, quote, Salvadoran public officials advertised on social media that the very poor prison conditions are what the gang members deserve, end quote. I mean, I'm not sure what else anyone can show about the Salvadoran government's intent then with their prisons. And remember, many CAT applicants don't even have attorneys. The BIA explains that it was insufficient because, quote, this evidence reflects the public officials' moral judgment about gang members. We should not simply assume that elected officials have a specific intent to torture based solely on disparaging comments about gang members, end quote. It could all just be political posturing, speculates the BIA. The BIA also believes that the IJ ignored evidence showing that the Salvadoran government was trying to improve prison conditions. Quote, the immigration judge has a duty to meaningfully examine the United States government reports on country conditions, especially the Department of State Country Condition Report, end quote. Quite the sentence, though, and remember it, as NPR and other outlets are reporting that the Department of State is about to cut out sections of its future reports that would be expected to have precisely the type of information needed by non-citizens to prove their case under this decision. That, of course, isn't the case with the Department of State report from 2022, which reports on steps to improve conditions and the punishing of some officials who committed human rights abuse in El Salvador, among other things. So again, make sure your expert reviews the whole record and is prepared to explain why your client will more likely than not be tortured or persecuted specifically, if that is, of course, your expert's opinion, as well as preemptively explaining why the discussions of improvements in the Department of State report and other improvements may not be all they seem to be, if that is in fact your expert's opinion. Having rejected the government-centered torture claims under clear error review, the BIA also disagreed with the IJ's finding that MS-13 members would more likely than not torture Mr. AAR with the acquiescence or willful blindness of public officials. The BIA sees unexplained speculation by the IJ. You need, for example, findings about the, quote, awareness of such activity, and thereafter breach of his or her responsibility to intervene to prevent such activity, end quote. Circumstantial evidence may sometimes support this finding, but it wasn't explained enough here for the BIA. CAT has, quote, exacting, end quote, requirements, and they were unmet in this case. And while the timing of this decision sure seems intended to align with current White House priorities, the BIA is quite careful to, quote, emphasize that individual factual circumstances differ and that the country conditions may change. Thus, the merits of any individual claim must be considered on a case-by-case basis, end quote. So I guess read this decision for what the BIA says it is. One case with an apparently deficient evidentiary record. Mr. AAR, however, is going back to El Salvador, possibly to stay in a prison that the U.S. is paying for, which would just be the most ironic of ironies. And that is matter of AAR. Moving on to Zhou v. Bondi, published by the Sixth Circuit on April 23, 2025. This case is about I&A Section 237A1H waivers, motions to reopen, and ineffective assistance of counsel. But really, it's about jurisdiction, so no ineffective assistance of counsel music for you guys. Can't just be giving it away. Everyone, including the Sixth Circuit, appears to believe that Ms. Zhou obtained conditional lawful permanent resident status and then LPR status through marriage fraud. It all came out when she applied to naturalize, and in removal proceedings, she applied for a Section 237A1H waiver, which, for better or for worse, is largely a marriage fraud waiver for LPRs. An IJ granted the relief. It's not, after all, the most difficult waiver to get. It's essentially a discretionary balancing test, assuming that the non-citizen has a qualifying relative and, quote, turns on the balancing of so-called favorable and adverse factors, end quote. Unhappy with her years of false testimony, though it seems, DHS appealed. Ms. Zhou hired immigration counsel to represent her at the BIA. But unbeknownst to her, counsel never filed an appearance with the BIA. So he never got the briefing schedule and he never filed a brief. So the BIA sustained DHS's appeal and ordered Ms. Zhou removed from the United States. Simply devastating. De novo review, after all, at the BIA, I believe, given the discretionary nature of the analysis. The BIA reweighed the facts and ruled against Ms. Zhou. When she received the denial, she contacted her attorney, who sent the BIA a letter asking that the decision be, quote, set aside, end quote. Should have probably filed a motion to reopen, but I don't know, maybe informal letters used to work? Then that attorney passed away 14 months later without anything further happening. New counsel came aboard and filed a motion to reopen because, of course, all of this is ridiculous. But that then required the BIA to equitably toll the 90-day motion to reopen deadline, which had long since passed. New counsel alleged ineffective assistance. The BIA declined to reopen. And the Sixth Circuit affirmed that. Actually, though, it didn't reach the merits at all. It held that it lacked jurisdiction over the whole thing. See, in addition to other things, any ineffective assistance of counsel motion to reopen, anywhere, I believe, must establish that the ineffective assistance likely caused prejudice. Quote, the key to this analysis is the effect on the outcome of the underlying claim, end quote. Now, Sixth Circuit precedent would bar the court from reviewing a discretionary denial of, say, a Section 237A1H waiver itself. So can you review the motion to reopen when that's the ultimate relief? The 11th Circuit has recently used similar logic to refuse jurisdiction over an ineffective assistance of counsel claim tethered to non-LPR cancellation of removal in Ponce Flores, episode 154. And that's kind of what the Sixth Circuit held here, quote, if we were to exercise jurisdiction, we would need to review the merits of that discretionary determination by the BIA. That is because the Lozada prejudice inquiry requires us to assess whether Ms. Zhou's counsel's deficiency would have made a difference as to the BIA's denial of the Section 237A1H waiver, end quote. Ineffective assistance of counsel prejudice is not a legal question that saves jurisdiction, explained the court. Almost pure discretion, unreviewable. Accepting the BIA's very hard-to-defend conclusion that her attorney's failure to defend a grant of Section 237A1H relief somehow did not prejudice her when, as a result of the failure to defend, the BIA reviewed the issues without Ms. Zhou's arguments and overturned the IJ's grant. No prejudice. Now, the Sixth Circuit expressly states that its holding is narrow. Quote, our holding does not disturb cases in which we exercised jurisdiction over the denial of a motion to reopen where the potential basis for reversal was something other than the BIA's lack of prejudice determination, end quote. Nor does it even preclude review of a Section 237A1H-based motion to reopen where the legal issue is something other, it appears, than a discretionary balancing of factors. But when the ultimate issue is discretionary for Section 237A1H and likely other reliefs, the Sixth Circuit is saying that it can't review a no prejudice-based denial of an ineffective assistance of counsel motion to reopen. Say that 5 times fast. Devastating for Ms. Zhou and other non-citizens in the Sixth Circuit. And that is Zhou v. Bondi. Next up is Hussen v. Bondi, published by the Fourth Circuit on April 22, 2025. This case is about asylum and motions to reopen. Mr. Hussen is from Ethiopia and applied for asylum in the United States. Seems like an immigration judge deemed him not credible, and the BIA affirmed. During the BIA appeal, Mr. Hussen married a U.S. citizen who filed a Form I-130 petition on his behalf. Mr. Hussen, either post-BIA order or while the appeal remained pending, moved to remand or reopen so he could apply to adjust to LPR status. He did, after all, initially enter lawfully as a tourist. The BIA, however, believed that the evidence of the marriage was insufficient and denied the motion. Then Mr. Hussen moved to reconsider that, showing that now his wife was pregnant. Decently sufficient. Denied. All of it's before the First Circuit, which remanded. Not on asylum, though. Quite the story based on his membership in the minority Silti ethnic group and the opposition Blue Party in Ethiopia. But this is a long week, and the agency deemed him not credible, and the Fourth Circuit affirmed, so that'll be that. To the court, the agency did enough there. Quote, in particular, the IJ found implausible the notion that Mr. Hussen would be targeted for arrest one day after attending as a casual participant a large government-sanctioned protest, when there was no indication in the record that the protest's organizers, or indeed anyone known to Mr. Hussen, had also been arrested after the protest. He also found it implausible that the government that had allegedly persecuted Mr. Hussen had hired him to a government ministry and then permitted him to leave the country. End quote. High standard to overturn the agency on adverse credibility and not met here. But the marriage adjustment of status-based motion to reopen and motion to reconsider? That's another story. Relying on the 2002 decision matter of Velarde Pacheco, Mr. Hussen submitted sworn affidavits about his marriage from himself and his wife, describing the circumstances of their marriage and courtship. Sufficiently detailed, it seems. The affidavits also described how the families had a celebration in Ethiopia when the engagement was announced. 7 more affidavits from family and friends were submitted, including some who attended that wedding at great distance. The marriage certificate and Nikanama was submitted too, it seems. Lots of photos. Plane tickets for the honeymoon. Hotel reservations. A lease agreement. Insurance cards. Photos of the family meeting in Ethiopia. What more do you want, BIA? Well, they even got a pregnancy, after the BIA denied the first motion. BIA, facilitating U.S. citizen births for the good of the nation. The Fourth Circuit remanded, as I mentioned. After all, explained the court, reopening is a, quote, important safeguard intended to ensure a proper and lawful disposition of immigration proceedings, end quote. Indeed. Supreme Court, quote, no less, Kukana, beholder. And I didn't know this, quote, Congress initially adopted a categorical bar to an adjustment of status based on a marriage that was entered into after removal proceedings had commenced, end quote. But because that was really, really harsh, and of course swept up valid marriages too, Congress amended the law to permit adjustment of status based on marriages that occurred during removal proceedings, so long as it was established by clear and convincing evidence that the marriage was entered into in good faith. And no matter when the marriage took place, the I-130 question always remains the same. Did the couple, quote, intend to establish a life together at the time they married, end quote. Remember it. The regulation at 8 CFR section 204.2A1 lists the type of evidence to submit to meet that standard, and case law has fleshed it out as well. And it seems that Mr. Hussen submitted all of it to some degree, and more. Importantly, because this is happening in the motion to reopen context, Mr. Hussen need only make a prima facie showing that he can satisfy the marriage during removal proceedings standard. Quite the important distinction to remember and argue in your motion to reopen cases. More, you say? Say less. Quote, matter of Velarde does not require that the petitioner establish by clear and convincing evidence that his marriage was in fact bona fide. It requires only that the respondent establish a strong likelihood that he would be able to demonstrate that his marriage was bona fide should the BIA grant his motion to reopen, end quote. In contrast here, the BIA was trying to hold Mr. Hussen, it seems, to the bona fide standard right then and there at the motion to reopen stage, before even giving him his day in court about it. Can't do that. That's much more than a prima facie requirement. Have I said remember it yet? Remanded due to the BIA's application of the wrong legal standard. And while the Fourth Circuit didn't go so far as to actually opine on the facts and legitimacy of the marriage, it does mention evidence of the recent child. We'll see what happens. And so, congratulations Daniel Aaron Diskin for petitioner. And that is Hussen v. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Welcome back! We have Oscar v. Bondi, published by the Ninth Circuit on April 23, 2025. Mr. Oscar is from Haiti. Like so many Haitians, he lived in South America before coming to the United States because Haitians have been fleeing Haiti to wherever they can find work and safety for quite some time now. Mr. Oscar landed in Chile before coming to the United States. That's going to be a problem for Mr. Oscar now in his application for asylum in the U.S., because both the asylum statute and regulations bar a non-citizen from obtaining asylum if they have previously, quote, firmly resettled, end quote, in a third country. TPS has some problems with that too. Looks like an IJ and the BIA found that Mr. Oscar had firmly resettled. It's a bit difficult here as the Ninth Circuit begins its decision simply by going through the law and not the facts for many pages. But in any event, the Ninth Circuit affirmed the agency. Review of firm resettlement is a mixed question of law and fact, explains the Ninth Circuit, which should be de novo review post-Wilkinson. But as the panel explains, quote, whether the agency properly applied the firm resettlement standard to a given set of facts is a primarily factual mixed question, and therefore we continue to review the agency's firm resettlement determination with deference under the substantial evidence standard, end quote. Not gonna lie, I don't quite understand that holding, but that's the holding. To establish firm resettlement, the government has the initial burden to establish a prima facie case that the bar applies. After that, there's a burden-shifting framework that actually shifts quite a few times. But if made, that is the prima facie showing, to rebut the prima facie case that, quote, an offer of firm resettlement exists, the non-citizen must show that the non-citizen does not have the right to return and remain in the third country indefinitely, end quote. Moreover, quote, ineligibility for third country refuge based on the non-citizen failing to take advantage of its procedures for obtaining relief does not rebut the existence of an offer, end quote. If the non-citizen gets the burden, and if the non-citizen can't meet that burden, they can establish that an exception exists, either by showing that the non-citizen's presence in the third country was necessary for, quote, onward travel, end quote, or by showing that the non-citizen's residence in the third country was, quote, so substantially and consciously restricted by the authority of the country of refuge that he or she was not, in fact, resettled, end quote. Those are per the regulations. Quite a lot of regulatory standards at work with firm resettlement, so read your regs and BIA case law every time. So then we finally come to Mr. Oscar, indeed from Haiti, and popular in his community because he was a, quote, literate farmer. End quote. The political party, Parti Haitien Tetkal, known as PHTK, tried to get him to join, I guess for this reason, but according to Mr. Oscar, it's also a violent gang. When he refused, they almost killed him and his now wife. He fled 2 months later after reporting the incident. He went to Chile in January 2015 and lived there for 6 years, and he had a child with his wife. He had many jobs and received health coverage in Chile. His wife received protection under Chilean maternity law. Probably most importantly, Mr. Oscar and his wife received Chilean identification cards with the words, quote, visa, permanent residence, end quote, on the back. On the other hand, Mr. Oscar experienced some pretty terrible and scary racism in Chile. He also believes that members of the PHTK followed him in Chile based on attacks that he suffered there in 2014. This sufficed for firm resettlement, said the Ninth Circuit. DHS definitely met its initial prima facie burden, at a minimum, based on that visa that literally says permanent residence. That's direct evidence, explains the Ninth Circuit. That means that Mr. Oscar had the burden to show that the bar doesn't apply, but the Ninth Circuit didn't believe that he met it. Quote, Mr. Oscar argues only that his Chilean residence status has since been revoked by operation of Chilean law. This argument fails. An offer of resettlement that has lapsed or been relinquished is still an offer and a bar to resettlement. End quote. Nor did he establish that an exception applies. Yes, quote, substantial discrimination, end quote, might meet the second exception under Ninth Circuit precedent. But the court didn't believe that that was the case here, given Mr. Oscar's many years apparently living a decent life in Chile, generalized evidence of employment discrimination and racism, and Mr. Oscar having a beer bottle thrown at him does not cut it to the court in light of his other experiences in Chile. Not only that, but the exception has a government nexus. The conditions of residence must be, quote, consciously restricted by Chile or by the authority of Chile, end quote, per regulation. Here at most, to the court, Mr. Oscar's experiences and the country condition evidence appears to show racism and discrimination by private actors. To the court, you have to have, quote, government action or knowledge, end quote, not present here. And so, Mr. Oscar and his family lost their case. And that is Oscar v. Bondi. Concluding with two from the First Circuit. First, Mendez-Nolasco v. Bondi, published by the First Circuit on April 23, 2025. This case is about non-LPR cancellation of removal. The First Circuit uses the first names of the petitioners to avoid confusion and expressly states that they mean no disrespect, and so I guess I will too. And I also mean no disrespect. Gustavo and Blanca are a married couple from Guatemala who have 4 children, and they're all U.S. citizens or lawful permanent residents. That is, the children. Gustavo's been here for 44 years, and Blanca for 24. They live in Massachusetts, are involved in their church, and seem like generally good people. They do have a few arrests and at least one conviction, though, undiscussed really in this decision. Gustavo runs a landscaping company, and Blanca works there as a bookkeeper and manager. They have 6 employees on payroll, possibly U.S. citizens. They have a home and reinvest in their community. One of their children is studying architecture. All the kids are doing well in school, though at least the youngest one doesn't really know Spanish. And of course, the parents testified that their removal will completely ruin the family's life financially and emotionally. Unsure why they were placed in removal proceedings, but Gustavo and Blanca were, and they are, after all, removable for having entered the United States without authorization all those years ago. Children don't qualify as qualifying relatives for I-601A waivers, so this couple pretty much has no path to legalize their status, except for non-LPR cancellation of removal in removal proceedings, limited to 4,000 grants a year and requiring, of course, a showing of exceptional and extremely unusual hardship to at least one qualifying relative child. Under the facts of this case, at least, of course. Not shown, said the IJ and the BIA. The IJ also found that the couple lacked good moral character because they hadn't initially disclosed their criminal history, but the BIA didn't address that, so it's not an issue before the First Circuit. The First Circuit, though, affirmed the denial of non-LPR cancellation, again punting on what the proper standard of review is on hardship post-Wilkinson. Whether deferential review or not, the First Circuit believed the petition for review failed, particularly as the petitioners here didn't challenge the legal standard employed by the BIA itself, but simply whether the facts of this case met it. Quote, all in all, the exceptional and extremely unusual hardship standard is supposed to be hard to meet, end quote. Thank you, 1996 Congress. First, the First Circuit believed the BIA applied its correct hardship standard and considered all the relevant factors in the aggregate. Next, the court believed that the petitioner's case here was distinguishable from the somewhat non-citizen-friendly decision matter of Racinus from all those years ago. Quote, that decision does not establish that the exceptional and extremely unusual hardship standard is satisfied whenever an applicant has multiple children who would need to learn a new language and who would face worse educational and financial prospects upon removal. Instead, the agency's decision in the matter of Racinus was based on the totality of circumstances presented in that specific case. End quote. At the end of the day, the First Circuit sees Racinus as worse than the facts in this case. Two of the children here are legal adults, and the parents make good money and seem to have money in savings. But it's still a good argument, everyone. Argue as strong as you can, at a minimum, to try to make your non-LPR cancellation case similar to Racinus. Plus, reasoned the IJ, and affirmed by the First Circuit, the oldest son could petition for his parents. Unstated by the court is that they'll be subject to 2 separate 10-year bars if removed and are not eligible for an unlawful presence waiver. But still, the fact that the son could petition was a factor that, to the First Circuit, the IJ properly considered. The First Circuit also believed that the IJ and the BIA considered all factors in the aggregate, including the dangerous conditions in Guatemala. And although the IJ didn't specifically make findings related to the couple's other family ties to the U.S., the First Circuit doesn't see how that would bolster their claim. After all, the family also has family ties to Guatemala. The IJ and the BIA considered the factors in the aggregate, and at the end of the day, deemed them the type of hardship that is, quote, expected, end quote, when you deport parents to developing countries, and those parents have to bring their children who have grown up in America. Thus, not exceptional and extremely unusual. So the First Circuit affirmed denial of relief for these parents. And that is Mendez Nolasco v. Bondi. You've made it to the end. Good job. With Chan Chavac Garcia v. Bondi, published by the First Circuit on April 24th, 2025. This case is about motions to reopen. Just like the last First Circuit case we did, the petitioners here are a married couple from Guatemala who have lived in the United States for decades. They have 4 U.S. citizen children, ages 9 to 20. Removal proceedings began for reasons unexplained. The couple applied for non-LPR cancellation of removal, but had their applications denied. The hardship claim was premised primarily on one of their sons, quote, LC, required medical and educational support and had been diagnosed with oppositional defiant disorder, anxiety and attention deficit hyperactivity disorder, ADHD, end quote. But to the IJ, the petitioners submitted limited evidence in support of this and on conditions in Guatemala. The BIA affirmed, despite the petitioners, through the same counsel, submitting new evidence about another child's learning disabilities. But they did not submit additional evidence about LC or country conditions in Guatemala, which is all to be expected as appeals aren't normally the time to submit new evidence. That's during the case in chief below. Then the couple filed a motion to reopen through the same attorney based on the COVID-19 pandemic, also denied. 2 years later, new counsel came in to file another motion to reopen. Untimely, of course, but they argued that the filing deadline should be equitably tolled due to the first attorney's ineffective assistance of counsel. This time, the petitioners, quote, submitted several sources detailing country conditions in Guatemala, end quote, including Department of State reports with information specific to countries for people with disabilities and in need of special education. They also submitted additional medical evidence for the children and evidence that a third had learning challenges. They also submitted proof of the state bar complaint filed against prior counsel and prior counsel's response. That's all because of matter of Lozada, by the way. Quote, in response, prior counsel explained that she did not submit country conditions evidence to the agency because she does not find that it is necessary in cancellation cases, and judges are very aware of country conditions for Guatemala, end quote. The BIA denied the motion to reopen, but the First Circuit sent it back. Assuming motions to reopen can be equitably told, the court believed the BIA's ineffective assistance analysis insufficient. Too, quote, thin, end quote, explained the court. And here's the claim stated plainly, so careful, everyone. Quote, in the removal proceedings, the agency found that petitioners had failed to submit evidence corroborating their assertion that LC's disabilities would prevent him from receiving an education in Guatemala. They contend that the prior attorney's failure to submit this evidence doomed their petition, end quote. Was this actually deficient, and did it prejudice the petitioners? The BIA didn't say sufficiently to the First Circuit. The BIA's conclusory sentence stating both elements, quite frankly, didn't cut it to the court. The critical question the BIA must answer in cases like this is, quote, whether corroborating evidence about LC's learning disability could have changed the agency's decision in the removal proceedings, end quote. Specific factual circumstances aside, the could have changed standard appears applicable in all ineffective assistance of counsel motions to reopen in the First Circuit. Important here because the IJ denied in part because the petitioners provided no evidence on whether LC would receive educational services in Guatemala. But then the petitioners seem to have submitted that evidence in their ineffective assistance motion to reopen. So how could the new evidence not have possibly changed the result? Inquiring judges want to know. Nor to the court did the BIA adequately explain why it was that the new evidence didn't establish a prima facie case for relief, given factually similar cases like matter of Monreal Aguinaga from 2001, and the country condition evidence submitted here, which goes specifically to the alleged hardships LC will face. Gotta consider it, BIA, where, like here, the U.S. citizen children have, quote, special needs, learning difficulties, or psychological diagnoses, end quote, says the First Circuit. A U.S. citizen child being deprived of an education is a serious thing that might qualify a non-citizen for non-LPR cancellation. Quote, if the BIA meant to hold that even if corroborated, being deprived of an education due to the lack of special education services is not an exceptional and extremely unusual hardship, we would have expected the BIA to explain why that is so, in light of its own precedent indicating the opposite, end quote. Ooh-wee. At the end of the day, the First Circuit just doesn't seem to think that the BIA explained itself nearly enough or did a very good job with their case citations and analyses. Seems to the First Circuit like the BIA kind of phoned it in, so it sent it back. Can you imagine if the Supreme Court's Wilkinson decision had come out the other way? Thank goodness for federal court review. Such an important thing. And congratulations, Val C. Ribeiro for petitioners. And that is Chanchavac Garcia v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.